So welcome everyone. I'm Sarah Matthews at the Reporters Committee for Freedom of the Press. I'm a staff attorney and I do a range of things, including heading up our pre-publication review practice. And I have the pleasure of getting to work with Dale Cohen at the UCLA Documentary Film Law Clinic. I think probably everyone here probably just knows you, Dale. But Dale also serves as special counsel to Frontline, the award-winning PBS documentary series. And so he's not only doing the documentary film work at the legal clinic at UCLA, as well as serving as an adjunct professor of law, but also working at Frontline. And we get to collaborate on our work with International Documentary Association grantees. So we divvy up those grantees from the Enterprise Award and provide them with pro bono legal assistance. Yeah. So just to get started, the way we divvied this up was I'm going to be talking about the gathering the news and the legal issues that come up in that context. And then Dale is going to be talking about the pre-publication vetting side, so focusing more on libel and privacy. I have a short deck here to kind of help guide our conversation on the news gathering side. It is a small group. We were expecting 20 people, but I think since we have a smaller group here, please let me know if you have questions as we're going through. Happy to answer them. So let me just share my screen here. All right, so as I mentioned, I'll be covering the first section on gathering the news. So I just want to start out with talking a little bit about releases because this comes up a lot in the documentary film in the documentary film context. So there are two issues here, really. The first is whether getting releases are legally necessary. And the second is whether you should get them, whether they are necessary from an industry perspective by insurers and distributors. And so from a legal perspective, you usually don't need releases. In fact, broadcast journalists typically don't get releases when they're interviewing, when they're gathering the news. Courts have recognized that the act of photographing or filming is protected by the First Amendment, particularly when you're filming in public and it's newsworthy events. And so in the news context, sometimes broadcast journalists do get releases or traditional journalists do get releases. It tends to be in specific contexts where the risk is a bit higher. And so it may involve minors, or there may be a particularly high risk of a potential privacy lawsuit. So you're maybe, reporting on the disclosure of particularly sensitive health information, for example, or if you anticipate wanting to use the footage or the photographs that you've obtained in a commercial context, you may want to get the release because you might anticipate a potential right of publicity lawsuit down the line. But those are the edge cases, and typically releases are really not legally necessary. But from a practical perspective, it's a good idea to get them because insurers and distributors increasingly are requiring them, and particularly where the subject on camera is speaking on camera and is on camera for more than just a fleeting moment or in a crowd scene. I think in those cases where someone's just very briefly on camera, insurers typically say, okay, we won't need a release in that instance. But other than that, they tend to want releases and distributors as well. And it's certainly easier to just get the releases signed at the time when you're doing the interview, rather than afterwards having to go back, track the person down, and get the release signed. And certainly, if you have to do this after the fact, you would really want to carefully consider the risk of flagging the fact that you don't have a release, and you would definitely not want to give the impression that you believe it's legally necessary, right? That you have the release, and you wouldn't want to suggest to the person signing the release that if they don't sign it, they could file a claim. They would have a potential cause of action against you. So what we found is if you can get the release early, that is going to save you a lot of headache down the line. And even if someone initially doesn't want to sign a release, but then they do the interview and it goes well, ask again. They may be more inclined to sign the release then. So that's just something to keep in mind. So I figured I would just focus on some of the the legal risks that we see most frequently in the film context. And so as a general rule, you do have a First Amendment right to film in public places. There are exceptions to this, but that's the general rule. But we just want to flag the potential civil or criminal liability that you could face while gathering the news. So this is not a completely comprehensive list, but there we go. But these are just the most common issues that we see. So just be aware that, you could face civil or criminal liability for trespassing onto private property. If you are filming and your video actually captures audio that violates a recording law, and we'll talk about this more later in the presentation, or if you are failing to obey reasonable orders by police. This is often in the protest context. That's where we see journalists most frequently being arrested. That includes documentary filmmakers. There's also the intrusion upon seclusion, which is a privacy tort. Dale will talk about privacy more generally, but that's a particular tort that we see in the news gathering context. And also taking photographs and video in violation of hidden camera laws. We'll talk about that as well. And taking photos and video of certain federal facilities is also prohibited. That doesn't come up very frequently. It's limited to federal buildings. So think military, military bases, prisons, federal prisons, and like border stations. So we don't really talk about that. I won't talk about that much because that doesn't come up frequently, but just be aware of it. So just moving into that. So just wanted to start with the background that generally applicable laws, right, civil and criminal laws do apply to journalists, including documentary filmmakers. And so, just because you are gathering and disseminating the news, and that is protected, that has some First Amendment protection, it doesn't mean that you have a special exemption from generally applicable laws. Those laws, do, as a general rule, apply to you also. So for example, for trespassing, it's not a defense to say, but I'm trespassing, but I'm a journalist. So there are some special exceptions to this. For example, where if you have been subpoenaed and you have certain protections that prevent journalists specifically from being compelled to reveal their confidential sources. But as a general rule, just know that laws apply to journalists the same way they apply to other members of the public. Of course, we always argue that prosecutors should drop any charges against journalists because they are serving this important First Amendment role, but that isn't always recognized by the authorities. Okay, so we talked about trespass, but when journalists are arrested, this is one of the common charges that they're charged with. So that is entering private property without consent or refusing to leave once asked. It often comes up actually in the protest context where, journalists are filming or reporting on a protest or demonstration, and it moves onto some private property, and then everybody is arrested because of that. So you can be sued civilly for damages or criminally prosecuted. Don't worry too much about this. You obviously don't want to break the law or trespass, but even in the criminal context, in many cases, these charges are ultimately dropped against journalists. but also it comes up in the ride-along cases. So where, journalists are riding along with members of law enforcement and then enter into someone's house. The police may not permit the media to enter private property without consent of the residents. So you have to get that consent. Okay, another common issue that comes up is misrepresentation. So this comes up in the context of doing undercover investigations. And so the general rule of thumb here is to avoid misrepresenting yourself because it could potentially create liability in certain circumstances. Many states have laws against fraud or misrepresentation. And so that is when you are knowingly, intentionally making a false statement or omission, right? You're specifically not omitting an important fact that causes somebody else to act on that misrepresentation, and it causes that person damages. Now, I included Food Lion here because the most famous case in this area is the Food Lion case, which has, I won't get into the complexity of that whole case because there are like many different claims, but suffice it to say that these issues did come up in that case. A couple of broadcast journalists were charged with fraud, trespass also, and a couple of other claims brought by Food Lion when they went undercover, applied to be employees, became employees based on fake resumes, and then disclosed the like rancid meat that Food Lion was selling, and it made Food Lion look very bad. The happy news on that was that although the court held that the journalists could be sued for trespass because they had not gotten permission to access the specific areas, like non-public areas of Food Lion that they were, that they had gotten access to based on their applying to work there, the court actually reversed the fraud claim, saying the ABC journalists could not be sued for fraud because the damages that had been suffered by Food Lion was not due to the misrepresentation by the journalists, but actually due to Food Lion's own bad practices that had just been publicized by the journalists. Now, this was just one federal court in the Fourth Circuit. So, we don't know if other courts would necessarily follow that, but it is a good rule of thumb to just be aware of these rules and try to avoid, making any misrepresentations if you can. And there are just, ethical concerns to that as well, which I won't get into since we're focusing on the law, but just to be aware. Okay, I'll just keep going here. So now I want to talk about recording laws a little bit, just because this comes up very frequently in the doc film context. We also run a hotline at the Reporters Committee, a free hotline for journalists, including documentary filmmakers, and recording law questions are like one of the probably, top 5 or top 10 most frequent questions that we get on our hotline. And so, every state has a recording law, and there's a federal wiretap law as well, and we will talk about all of that. But I wanted to just start with some like broad sweeps here. What are kind of like the broad rules the general rules you should be thinking about? It is generally illegal to record a conversation where no party has consented. So that would be, these are just sort of across the board rules. No party has consented, and it's either a phone conversation, because people, the idea here is people would have a reasonable expectation of privacy in that phone conversation, or if it is an in-person conversation and people had a reasonable expectation of privacy there. Okay, we'll talk about that more in just a minute. Okay, so what if you're recording in public? So if you're in public, generally, if the parties have no reasonable expectation of privacy, it is generally okay to record those in-person conversations. So then the question is, well, what is a reasonable expectation of privacy? Unfortunately, it's very fact specific. So when courts assess whether there's a reasonable expectation of privacy, they look at all of the circumstances, all of the facts. And so you want to consider facts like, are people talking loudly? Was this in a very public place, like a park or a sidewalk? that are traditional public forums, where there are lots of people around? Would a reasonable person think that they had some expectation of privacy here or not? Were they whispering, or were they speaking loudly? Could passersby also hear them? So those are the factors that you want to consider. Now, just talking about specific laws. So as I mentioned, I think almost every state, if not every state, has a recording law. For the vast majority of these laws are one-party consent state. That includes the Federal Wiretap Act as well as about 38 states and the District of Columbia. So they allow you to record a conversation with one party's consent. And so if you were a member of that, if you were a participant in the conversation and you're consenting, that's fine. But if you're not part of the conversation, you need to have at least one party's consent. However, there are about 12 states that require all parties to consent to the conversation before it's recorded. And so, just some of the states where we've dealt with this before are California, Pennsylvania, Maryland, Florida, Massachusetts. So in those states, you want to, just make sure that you're getting all parties' consent. If you can get that consent recorded, great. If you were filming with a big camera, the person is, you're conducting the interview, or like they know they were on camera, that consent is implicit. But it's always, helpful to make sure that you do have consent before you just start recording. And it's really important that you follow the laws because most states have criminal penalties for violating the recording laws. So it's not just, it's civil. There's civil liability. You could be sued for damages, and in some states, the person who is recorded can sue not only for damages, but they can also get attorney's fees paid, which is an incentive to bring a lawsuit. And so just keep that in mind. And we actually have just updated our recording law guide on the Reporters Committee's website. So that link is right here, rcfp.org/recording. And we have every state listed there and what all the penalties are. So that's a good resource.
It's a great resource. You're being modest.
Thanks, Dale. So one question we get all the time also is, well, what about calls between people in different states, right? So like, what if I'm in California and I'm calling someone in New York? So California is an all-party consent state. New York is a one-party consent state. What law applies? The answer is the courts disagree on how to handle these cases. And so the safe course of action, what we always advise, is to go with the more conservative state's law. So go with the all-party consent state, make sure you get all parties' consent. All right, related to recordings, another issue that comes up a fair amount is what I call the Bartnicki issue. And this is where, folks call us and they say, okay, I got this recording that someone else made. They made it illegally. They didn't get consent, but I had nothing to do with it. But I want to broadcast it or publish what I found, what they said. That is protected by the First Amendment. So you have a First Amendment right to publish a recording, even if it was illegally made by someone else, if you were not involved in the unlawful activity, and it is a matter of public concern. And typically when we hear from journalists, it's a matter of public concern because it's newsworthy and they want to write about it. So that's some of the happy news I can give to hotline callers when they call with that question. But yeah, that was a great decision. And the last time the Supreme Court has had a press freedom case on its docket in a while. So, all right, just keep moving here.
And we're in no hurry to have them.
Yes, and that's fine. Yeah. So the right to record police in public. So this is actually where the action has been in terms of the case law developing on the right to record in public places. So we've now seen 7 federal courts of appeals across the country that have recognized a First Amendment right to record the police performing their duties in public. And that, I should add that is every federal court of appeal that has considered the issue. So I would say there's a pretty strong and broad consensus on this. And so, but this is not an absolute right, okay? So it is still subject to reasonable time, place, and manner restrictions. So this comes up in the context of protests, journalists, broadcast journalists, filming the police in public, or citizens, taking pictures, filming the police in public, often at demonstrations, and the police may say, stand over here. We're trying to effect a lawful arrest right here. Like, move out of the way. You're in the way. If you don't move out of the way, you could be arrested. And that happens not infrequently. We've seen a number of arrests, actually like dozens and dozens of arrests recently of journalists at protests in the last few months. Not always in this particular context where, sometimes it really runs the gamut as to like the context when police are arresting journalists. But the restrictions on the right to record must be reasonable. And they can't just say, well, you just can't record this, right? That's not permitted. And journalists also have the same right as members of the public. So the police also can't say, we just don't want the press here. Like, we don't want this reported on. That is unconstitutional. So that's good. That's the case law in this area is generally like pretty strong, and and we hope that it will continue to develop this way. But just remember, you could be arrested for failing to follow police orders. In fact, in many states, it is a crime to resist an order. And journalists, when they are arrested at protests, it is usually for these low-level, like misdemeanor offenses, like unlawful assembly, obstruction, trespass, like I said. All right. So there is this privacy tort that comes up during the news gathering context that I wanted to touch on. This is called the intrusion upon seclusion. And so it's essentially a privacy tort that allows damages for highly offensive intrusion into someone's solitude or seclusion. So the first question is like whether someone actually had a reasonable expectation of privacy. They had to have a reasonable expectation of privacy in order to be able to, to file a lawsuit, to have an actual claim. And also it has to have been highly offensive. This usually comes up in the context of, maybe it's a ride along, or you're covering like this, you're covering an accident on the side of the highway. And what courts have held is that, if this is in public view, you're on the side of the highway, you can record what's happening here, that's fine. But when you get into if you get into the ambulance, and this is a real case, or you get into the helicopter, you get into the chopper, and you're suddenly recording the communications, but the conversation between the medic and the person who's injured, you're now intruding on that person's reasonable expectation of privacy, and that would be considered highly offensive. And so that's where we could get into trouble. Or if you're recording in some private place, like someone's house, someone's bedroom, like a locker room, that's where you can get in trouble here. Okay, so along those lines, sometimes folks want to use hidden cameras, and there are a host of potential risks here. So many states do have hidden camera laws. We actually include the hidden camera laws in our recording guide that I mentioned. And so the good news about the hidden camera laws is that they tend to be much narrower than recording laws. And they just prohibit filming in private places. So somewhere where someone would have a reasonable expectation of privacy. It's usually like bedrooms, bathrooms, locker rooms, those kinds of places where someone would be changing clothes. And so, usually the hidden camera laws like don't just aren't relevant in the news context because folks aren't doing that, which is good. So just always think like, could I be violating the hidden camera laws? Could I violate the recording laws if I'm recording audio here? So look at the recording laws in your state. And could this lead to a privacy lawsuit like we talked about, an intrusion claim in particular? So the relevant factors would be, is the camera in public? Do people have a reasonable expectation of privacy? All of that. And then public records. These are probably like the most common questions we get on the pre-pub side when folks have, want help before we've actually gotten to the vetting stage. And so just a couple of quick things on this. I mainly want to flag our resources because I am not the FOIA expert myself. I do pretty much everything except FOIA, but we have some really fantastic resources on this. So FOIA, that is the Federal Freedom of Information Act, and it creates a statutory entitlement it allows you to get access to federal agency records. And now every state and the District of Columbia, they all have public records or sunshine laws, although all of these laws vary dramatically depending on which state you're in. But we have some great resources to help you with this. So for FOIA, we've got the FOIA wiki, it's just foia.wiki. And we started that, and that is sort of like an open source resource for FOIA. And it helps you understand, what kind of records you can get, what the exemptions are. And we also have ifoia.org, which is a resource that helps you create, submit, and track FOIA requests through that site, and like helps you kind of just organize them. So it'll send you notifications so like when to follow up with the agency when they haven't gotten back to you, which happens all the time. Also, if you're trying to get state public records, we have a state-by-state guide, the Open Government Guide. So you just go to rcfp.org/OGG, and you can look at, your state's records. These are like very lengthy, chapters on all the public records issues in that state, all the, not only public records, but also the public meetings rules in that state. So the takeaway on public records is that these can take a very, very long time. So submit your request as early as possible. It may take months or even years. And if you can get information from the state agencies, do that because those tend to be faster than federal. So just a few tips on this front. Think about if someone has already obtained the records you want, that can save you time if you just get those records from that person. Are they available through the agency's reading room or vault? So a lot of agencies will just publish the records that they have already given to, that they have already produced for other requesters. Like I said, if you can get the records from the state agency, that might be faster. You need to reasonably describe what you're asking for. And so, you want to be precise. Think about using keywords, dates, and names to limit your requests. If you use open-ended language like pertaining to or related to, you may, there's actually FOIA case law saying that is just too broad and the agency doesn't have to respond or doesn't have to, doesn't have to comply with that because it's just overly broad. But you can use things like, we're mentioning this person's name or referring to this particular, name or incident or, whatever it is. And because you are documentary filmmakers and you are gathering information to disseminate it to the public, you're probably entitled to a fee waiver. And if it's in the public interest, which it most likely is, you can get a benefit as well, a fee benefit. So you definitely want to ask for that. And this is all in the FOIA wiki, I will add. So in terms of court records, sometimes documentary filmmakers, are focusing on court cases and they want to get access to records to help tell that story. Again, this can take a long time, usually not as long as FOIA, but it can still take months or potentially even years to unseal records or get a protective order lifted in a case. But the nice thing about using court records is that the fair report privilege applies, which Dale may be talking about this more, but this is a privilege that applies, that protects you from being sued for libel if you fairly and accurately report on a government official, like an official government report or court proceedings or official like government, other government meetings. So on this, we have another great resource, which is the Open Courts Compendium. And this is a state-by-state guide. So you can look up what the law is on court access in your particular state where you are, or the federal appellate jurisdiction. And just lastly, I want to touch on cameras in the court, since this comes up not infrequently. So the Supreme Court has recognized, it's held that there is no First Amendment right to have cameras in the court. Excuse me. So, initially courts were very concerned that this could be prejudicial to the defendant in the case and witnesses, but they have since recognized that cameras are not necessarily prejudicial, as cameras have gotten smaller over time. And the Supreme Court has said that states can adopt their own rules on this issue. And they have. So today, all state courts allow some kind of courtroom photography or recording, but the rules do vary significantly. Typically, judges often have discretion in this area, but for the Supreme Court, still no cameras. Since, however, the silver lining of COVID has been that the Supreme Court has gotten more transparent in the sense that they now provide a live audio feed for their arguments, which they never used to do. They used to get oral argument audio at the end of the week. So that has continued. And for federal appellate courts, they may allow video recording, but only 3 of them do. They do their own video recording, and that's the Second, Third, and Ninth Circuits. For federal district courts, though, the recording is generally prohibited, but there are some exceptions. They have like a model program, a model like pilot program that they have done, and that is it. I'll hand it over. If there are any questions on that.
There are a couple of questions in the chat, Sarah, from Ethan Eisenberg. And so the first question was, what if the order, I assume that we're talking about the police when you're filming out on the street or in public, what if the order is to stop filming?
Yeah, so this is a sticky wicket because that's probably not constitutional. Like if you were to challenge that in court, the court would probably say, well, that's not a reasonable time, place, and manner restriction. You can't just say there's no filming. But at the time, if you don't follow the order, you may get arrested, right? And you can challenge the arrest, you can have a good argument, but you could still get arrested. And do you want to go through that? So, this is a challenge, and it's ultimately a judgment call as to how to handle it. But sometimes journalists can explain, I have a First Amendment right to be here. Is there somewhere I can stand? Like I can move away? Like, would you like me to stand over here on the sidewalk? But it is a hard one. And ultimately, it's going to be a judgment call for like how much risk you're willing to take.
It's a really serious risk. I mean, what I typically tell photographers and videographers is, it doesn't matter how good your legal arguments are. These are people who are carrying handcuffs, batons, and guns, and now even more innovative weapons, apparently. So you have to be really careful about it. I do advise them that they record the interaction that they're having with the police officer as long as they can, so that they can record the fact that they're being unconstitutionally restrained. Because that may come in handy later, but the cops may stop them from doing that as well. But as much as they can record, they should try to record without getting themselves beaten up, jailed or worse.
Yes, absolutely. I'm actually going to drop into the chat a tip sheet that we put together on this for covering protests. And so that covers all those things. And yeah, we always tell people the same thing, to just record as much as you can, because having that documentary evidence after the fact can help you get the charges dismissed. It can also help you if you bring a civil rights suit. So it's really key.
Ethan had a second question. Is it legal for someone who has already obtained public records to charge for passing them on?
Wow, I haven't come across that one. Is it legal? I mean, well, I guess first, I don't know. I guess somebody could charge for public records they've already obtained, but you could just go to the agency and say, like, I know in fact, many agencies, like I was saying, they have a vault, right, or a library room, and so they would just publish all that information. So you could just get it there or directly from the agency if they've already submitted it. But yeah, I mean, I guess there are some
Ethan, are we
enterprising
understanding
people.
the context for the question? Because I'm not sure I am.
Okay, Dale, I'm afraid I've cut into a lot of your time here, so I want to
It's
let you
perfectly
get
okay.
going.
Okay, this is all really important stuff. So hi, I'm Dale. As some of you know, because you've been in other panels that I've worked on, I run a pro bono clinic out of UCLA. In fact, one of the students in the clinic, Alberto, is on the call, and one of my other students at UCLA from a different class, Kate Sorda, is here too. You can see her. Uh, anyway, let me just jump into it. Vetting for content risk is very different in many respects than what Sarah was talking about. You know, unlike the news gathering side, where the law and our protections, frankly, are a little spotty, and the courts have been a little inconsistent in protecting news gathering under the First Amendment. On the content side, we have very good protections. However, if you make a mistake on the content side, it can be very costly and problematic. So when I work or the clinic works on vetting for content risks, I mean, I want to give you some sense of how I think doc filmmakers and journalists can work with lawyers most effectively. And the best way to do that is to tell you what I think the lawyer's role is and how you should view the lawyers. I mean, we're not, a good media lawyer is not trying to eliminate all risk when they're working with you on investigative reporting. It's almost impossible to eliminate all risk when you're doing this kind of journalism, right? And any lawyer who's trying to eliminate all risk, unless you ask them to do that, which is your prerogative, is really overstepping the bounds in my view. I think the role of the lawyer is to tell you what the risks are, to help you reduce the risks if that's what you're looking for, and overall to make, to help you tell your story in what is the safest way that you can. But again, there's always the risk that somebody is going to file a lawsuit for reasons totally unrelated to the fact that they're likely to win a libel or privacy claim, right? What's a nice word? The Republican candidate for the presidency is famous for filing bullshit libel suits. He has filed more than a dozen of them, and he does not file them because he expects to win, right? Sometimes these lawsuits get filed for public relations purposes. Sometimes they get filed for ego purposes. Sometimes they get filed, and this is the dangerous category, where they're just trying to punish the journalist, right? And make you spend a lot of your time and money dealing with them because they're pissed. And there's a secondary benefit to the plaintiff in that situation because it deters other people from telling similar stories, right? Before they pull the trigger on their stories, they're going to say, oh my God, do I really want to get myself caught up in this? Which can unfortunately be a very smart strategy, especially for a deep-pocketed plaintiff who has easy access to lawyers like the Republican candidate for the presidential slot. I won't even dignify him beyond that at this point. Okay, so what I want to know as your lawyer when I'm doing vetting is what's your risk tolerance, right? From my perspective, and let's keep it in the context of film production right now, my view is you as producer or director or both have final cut, right? And that includes on the legal risks, right? My job is to tell you what the risks are, to help you figure out what you're willing to take on and what you're not willing to take on. So the more that you can tell me about your tolerance, the more you can tell me about your background, the more I can see the kind of work you've done before, the better the advice I can give, and the better overall vetting we can do of your film. Okay, I have worked with lots of different journalists. I've worked with lots of different journalism organizations. Sarah can tell you the same thing. Every organization's a little different. I've worked at places that have said, I don't care if we get sued as long as we're going to win the case ultimately, right? I've worked with news organizations that have said, we don't have the time or the money to get involved in lawsuits. So if there's something here that you think is going to get us sued, even if we're right, I need to know about that and I want to be sensitive to it. And then there's all kinds of in-between positions. That's true not just on libel and privacy, but yesterday, for those of you who were there, it's the same thing is true on fair use issues as well, right? The client's risk tolerance and is key to this vetting process and how I can best help, or how a good media lawyer can help you in putting together your film and avoiding trouble that at least you don't anticipate. And you know, there's always the chance somebody is going to come out of nowhere and file a lawsuit. And in fact, many of the worst libel and privacy suits come not from the subject of stories. They're the people who are on the fringes, you know, who sort of got hit or their collateral damage. And you have to be careful about them. You know, when BuzzFeed ran the Steele dossier, I doubt that they thought that Alex Gubarev was mentioned on one page near the end of the dossier was going to be the one that was going to cost them a fortune. But he is the one that filed the most troublesome lawsuit that happily is going pretty well for BuzzFeed, right? But they weren't thinking that Alex Gubarev, this internet businessman, was going to be the problem. They were thinking about Trump. Okay, so let's talk about libel substantively. I mean, just for clarity, so everybody's on the same page. Defamation or libel and slander is effectively the same thing these days. There's no real difference between slander and libel anymore. Is harm a statement, a false statement of fact that causes harm to the reputation of the person or entity that you're doing your story about. It's not about hurt feelings. It's supposed to be about harm to their reputation. And so generally speaking, what we're talking about is allegations of crime, unethical behavior, incompetence, and other things that would tend to make people either not want to do business with you or not associate with you in the community. And you know, I've worked on lots of different libel suits. My personal favorite are the ones that allege that you know, people will no longer sit near them in the church, you know, or that you know, a relative is no longer taking their phone calls because of this news story. Those make for very interesting depositions, by the way. But those are the kinds of allegations that are necessary to rise to the level of libel. One thing that is clearly not libel is name calling, or what gets referred to as rhetorical hyperbole, right? Really over the top stuff, clearly opinion statements that may or may not be provably true, but on their face look like it is just an expression of opinion. And that area gets kind of dicey, but we've seen lately that the courts are very receptive to the notion that many of these statements are really not statements of fact. The Republican candidate has won several cases on that front, including most recently against Stormy Daniels, after saying that she was engaging in extortion. The court said, oh, everybody understands this, you know, the way he talks, and he wasn't really accusing her of a crime. He was just saying in his own hyperbolic way that what she was doing was wrong. Rachel Maddow won on this theory in the lawsuit that was filed by the OAN network. Talk about great ironies. You know, the OAN network claimed that she had defamed them by falsely stating that they were a Russian tool or you know, acting on behalf of the Russian government. And the court said it's so obvious that she was engaging in rhetorical hyperbole and expressing an opinion about how awful their content is. You know, arguably, that one could have been a statement of fact, but I think the court was willing to give her some leeway. Tucker Carlson just won one against Karen McDougal, another one of the Republican candidates' imbroglios. So hard to find good words that are not offensive. And Carlson, again, had suggested she was a liar and was engaging in a form of extortion. And he too got out. What made that case particularly interesting and amusing was that Fox actually argued in their briefs that nobody really thought that what Tucker Carlson was reporting was a fact. And the judge sort of picked up on that and in the opinion said, given his reputation, his audience understands that he's not reporting facts. He's offering his opinion. I wish I thought that were really true, but in that case, that the court was willing to let Tucker Carlson out on that theory and clearly slipped that language in there as a kind of, gotcha. Very enjoyable to read the case, though, as somebody who works for a different kind of media organization. Okay, so next question is, when it comes to things that I can recommend to help people when they're working on these investigative stories, and presuming as I must that almost all journalists, almost all filmmakers would prefer to avoid unnecessary risk. I mean, very few of the filmmakers or journalists I've worked with have said, hey, I don't care, I'm telling this story, right? Rudy Giuliani's latest, bullshit story, to the contrary. Most real journalists want to not take unnecessary risks. So among the recommendations that I make to filmmakers, let's stick to filmmakers at the moment, is I almost always urge investigative filmmakers to hire somebody independent to do some kind of fact checking. I think that's really important. It doesn't cost that much unless you've got a really big project or a really involved project, but it's an incredible amount of protection. And having somebody do the fact checking who's not involved in your reporting or is not, one of the key people who started on the project and has been basically pushing your thesis all along is really helpful. Now, I admit I come from the Chicago School of Journalism, where when I got introduced, the City News Bureau had as its favorite phrase, if your mother tells you she loves you, check it out. Skepticism and reporting against yourself seems really valuable. And I can give you probably 30 different stories where fact checkers found things that were just incredibly valuable saves that kept us from getting in trouble totally unnecessarily. Things that seemed on their face like they were completely plausible and probably true, but turned out not to be, right? Because the fact checkers, were able to dig something up, right? Think about the Rolling Stone case that happened just a couple of years ago with the rape on campus, or the alleged rape on campus. How valuable it would have been if, a very good reporter who basically fell under the spell of a young woman who told her a story that was completely plausible about sexual violence on the University of Virginia campus. But how valuable would it have been if there had been an independent fact checker who had been looking into that and had sort of checked her biases and reported against the assumptions she made. And on the surface, that story sounds to all of us like, of course that could happen. Sexual violence is happening at universities all across the country. We know that, right? So the story sounds like it's solid. But unfortunately, she didn't have anybody fact checking, and her editors didn't make her run down all of the little clues and things that were inconsistent. And as a result, as we now know, not only did the jury crush Rolling Stone at trial, but then the fraternity was able to sue. And frankly, even worse than that, and this is what's really important to Frontline or the New York Times, or, and I think to many of the doc filmmakers I work with, their credibility was really hurt. Really hurt. When people think about Rolling Stone, at least in our industry, it's one of the first things that comes to mind is, oh my God, the Ramos story, that the University of Virginia story was a disaster. I don't know how that happened, but Am I really going to treat them as a really strong source for investigative journalism? I'm at least skeptical going in. Okay, so that's one. The second one is follow good journalistic practices, right? Good journalistic and ethical hygiene is enormously valuable. Again, very similar to bringing in a fact checker. Having multiple sets of eyes and multiple brains thinking about things and reviewing them is by far better than just the solo venture, the Lone Ranger approach to telling stories. Right? Again, I don't mean to pick on bad stories, but we've had a few lately. The Sarah Palin New York Times case is an example of a senior editor who rewrites an editorial opinion that from one of his subordinates. Nobody checks it to make sure that when he rewrote it, that his facts are straight. It goes right to press, and he makes a big mistake that is now likely to lead to a trial next spring that may not go very well because he made a big mistake about a sensitive subject. And while Sarah Palin may not be the most attractive plaintiff, really his defense is, oops, I forgot that there was no linkage between Sarah Palin's PAC and their bullseye ads and the shooting that took place at the congressional softball game. I mean, at Gabby Giffords' political rally. I forgot is really not a compelling argument to make to a jury. It's very funny when Steve Martin says it as part of a comedy routine. But juries are not going to be impressed that the newspaper of record and their top editorial editor simply messed up. Right? So if somebody else had their eyes on that, even not a professional fact checker, that might have helped. And in fact, that's how they discovered the mistake. It was not the complaint from Palin. It was one of their other writers who called them a couple of hours after the story was posted and said, "Are you sure about this? I don't think that's right." Other good journalistic practices help too, right? Making sure you've got reliable sources, making sure you've got multiple sources, not relying on just one, whether they're on the record or anonymous. Just a single source for a serious allegation is a really scary proposition. And then another one of my particular favorites, and it's not always possible, but I very frequently recommend to filmmakers that they give the subjects of their story the opportunity to reply. Like a real opportunity, not just a phone call the day before you lock the film, but something in writing or a serious phone call to say, here's what we found in our reporting. What's your response? Do you have any response? Do you have any comment? That serves multiple purposes. The first one is it can help you catch mistakes sometimes. It can also lead to discovering new information and better information than you already have. One of the interesting things I've found working with investigative journalists over all these years is that the subjects of your story know more than our best reporters do about their foibles and mistakes. And they're really super paranoid that you know more than you do. Which is great, but sometimes you can get them talking about things that you didn't already know. And I'll give you an example of one that happened in Frontline's case when we did a film about Harvey Weinstein and the Weinstein Company. We went out with right of reply letters and raised a variety of allegations that had been given to us, or statements that had been made in the press or to our filmmakers. And asked for comment. And the Weinstein Company, for its own reasons, was in the midst of distancing itself from Harvey. And they gave us all kinds of new information that we didn't have before in their responses to the right of reply. So we'd ask questions like, were you aware about the circumstances surrounding this person's, harassment or sexual violence? And their answer was, We weren't aware of it at the time, but we became aware of it at this later date, and here are the steps that we took, right? We didn't have that information. They volunteered it because of their own purposes, and it helped make the story better, right? It fleshed out the details. So sometimes you get lucky that way. And then, of course, the last thing, and this is what we're talking about, so I don't need to encourage you guys, but a good lawyer vetting is really important on investigative stories, right? Again, good lawyers are going to help by pushing back and being skeptics. One more set of eyes and one more skeptical set of brains to say, maybe that doesn't sound so great. You know, you've all heard the term actual malice, and you've heard that when you're writing about or you're filming or doing stories about public officials and public figures, that's the standard that's got to be met, right? That it's a very high standard. It's tough for them to win. They have to prove actual malice. As several of my students can tell you, we spend a lot of time talking about what the heck that word means, that phrase means, because it's really hard to define. One of the hardest things I've ever had to do in practice was trying to write jury instructions to explain to a jury what actual malice is. You know, it's either a knowing falsehood or reckless disregard for the truth. And reckless disregard has been defined in 3, 4, 5 different ways by the courts. Here's the best way I can describe it to those of you who have not had the misfortune of reading all those cases. If a story sounds too good to be true, be careful, right? Too good to be true starts getting you into the realm of actual malice, right? Particularly if you don't have multiple sources, or if you have multiple sources who are all aligned in interest and appear to be, you know, cross-checking and coordinating their story to you. And that's what good lawyering will often help you with, is that frankly, we're trained from the get-go, from our first year in law school, to spot issues and things that sound too good to be true. So good legal vetting is really necessary. Last thing in libel to talk about before we get to privacy is something that's called libel by implication, or sometimes is referred to under privacy as false light. And those are situations where your facts are right, but you've strung them together or used them in a way that creates a false impression. And the most obvious example I can give you, particularly for filmmakers, is when you use B-roll or pictures about something, you know, that shows somebody while you have sync or voiceover that's talking about somebody else or some general trend, right? So think about the film where you're doing something on opioid addiction and how it's overwhelming a community. And the video that you're using while you're talking about how horrible opioid addiction is you're showing pictures of street scenes and people who look kind of grungy, but are clearly identifiable. But you didn't talk to them. You don't know if they're opioid addicts, if they're part of what you've been talking about. You've just made an assumption. That could be a libel by implication or a false light situation. You know, I can give you lots of examples of that, but that's as good as I can give you as filmmakers, right? Be careful when you use B-roll in connection with talking about crimes, unethical behavior, incompetence, right? Because that mismatching of picture and words may get you into some deep trouble, even though you didn't say anything that was false. Okay, questions about libel before I move on to privacy? Ethan, you asked about libel by implication. Did that answer your question? Okay. I'm going to talk about privacy. So in particular, you know, I mean, Sarah's already covered intrusion upon seclusion, which is a physical aspect of privacy. And I mentioned false light briefly. False light is typically not that big an issue. In fact, there are several states that have said that false light is really just libel by implication. A couple of states have said there's no such thing as false light in their state, but I think I've given you a feel for that. The privacy element that I do want to talk about is the public disclosure of private facts. And this is the one where you can get yourself into some deep trouble, again, despite the fact that what you're reporting is absolutely true. The tort of violation of privacy by public disclosure of private facts depends upon a couple of key elements. The first one is the facts have to actually be private. So there are several very famous cases that even though people were offended or felt like the story shouldn't have been told, they lost because a lot of the public already knew the facts. It wasn't really private. Maybe the most famous case in this space for lawyers involves a guy named Oliver Sipple, who helped save Gerald Ford from assassination during his presidency in San Francisco. Oliver Sipple was gay, and at least with respect to his family, he was in the closet. He was out there, however, in the gay community in San Francisco. And for reasons that are still a little obscure, some leaders in the gay community decided to out Oliver Sipple as being gay because they thought that it would combat the prejudice and stereotypes about gay men not being brave or patriotic or good people. And they outed him. And there was a big story about Oliver Sipple and how he had saved the president, and how after the president discovered who he was, he did not get the honors and treatment that he probably should have as an American hero. The problem is that Oliver Sipple was very upset because his family back in the heartland didn't know. He had never come out to his family, and it ruined his relationships with an awful lot of people. And so he brought a lawsuit, but the court rejected the claim, saying a lot of people already knew this. These weren't genuinely private facts. It was public. It was private to a few, but it wasn't really a private fact, and therefore no claim. So that's one element. A second element is that whatever is revealed has to be highly offensive to a reasonable person. And that's a pretty high standard most of the time. And I will tell you that most cases don't rise to that level, except that things having to do with sexual activity and nudity and bodies, because we have such a puritanical streak still here in the United States, do rise to that level. And the most famous case in this space would be the Hulk Hogan Gawker case, right? A sex tape about a guy who was on a regular basis bragging about his sexual prowess and the size of his organs, and may or may not have been complicit in putting together a sex tape and releasing it into the wild, managed with the support of a Silicon Valley bad guy, I would say, funding him to put Gawker out of business. Now, you may or may not shed any tears for Gawker, but it's really a kind of stunning result, all based on something that really doesn't seem like it would be highly offensive to most people. If you don't know much about the Gawker case or how it all unfolded, Jeff Toobin wrote a great article for the New Yorker that I'd highly recommend to you. That really sort of takes you through the whole saga. And it's pretty outrageous, although it was also very clever lawyering, because ultimately they made this interesting argument that Hulk Hogan is a character, that Terry Bollea, which is his real name, is a real private person, and that when he was talking about his sexual prowess and bragging about himself, that was in character. But when he was in the sex tape, he was out of character and acting privately. I wish that had made it all the way through the appellate process, because I really believe that result would have been at least reduced or maybe overturned. But unfortunately, Gawker ran out of money and support and ultimately settled and closed down. The third and the saving aspect of this public disclosure of private facts question is, in virtually every state, it's required that the plaintiff has to prove that this private fact, even if it is private, even if it is offensive, is not newsworthy, that it's not a legitimate matter of public concern. And most cases, you're going to win on that, because if you're, as a journalist, you're reporting on it, most of the time there is a legitimate public concern. This is tied in some way to an interesting story that you've concluded that the public should know about. Again, you need to be careful though, because if it's sexual in nature, the courts are really prudish, right? If it involves children or the elderly or the infirm, the courts tend to be more protective and say that it may not be quite as newsworthy because they're more protective of the vulnerable. So this is a good place early on in your story, before you're fully committed to it, to talk to a lawyer and ask about the privacy considerations, because we can walk you through where on the spectrum of each of those elements you're likely to be, and ways that you can improve your case and still tell your story. All right, we're almost out of time, so let me stop and see if there are any other questions. Privacy, libel, news gathering, any of those things. I mean, as you can probably tell, Sarah and I could talk about these things for many hours, and we do. I mean, I encourage you to reach out to the Reporters Committee. That it's a fabulous group of lawyers who provide all kinds of pro bono help and have great resources. Reach out to us at the UCLA Clinic. We work with lots of filmmakers, and our object at the clinic is not only to help the filmmakers, but to train the next generation of media lawyers, so that there'll be lots more Sarah Matthews and Dale Cohens out there. That's what Kate and Alberto and another one of our students, Taylor Rafanti, has joined us. That's why we do this. We're trying to seed the clouds, so to speak. So please feel free to reach out to us, and if you've got questions, and hopefully we'll be able to help you going forward.
I have a question.
Yeah, go ahead.
How do you fact check
Ethan,
when you have a
exist.
Sorry, it was too noisy before to talk. How do you fact check when you have a confidential source? How do you get a third party to fact check, and what can you involve a lawyer? Like, what are the problems about involving other people in that situation?
Well, that's a really good question. So, first of all, every confidential source, the relationship is a little bit different. I mean, I typically, if I have the opportunity with our reporters or producers, try to get them to be really specific up front with the source about what the promise of confidentiality entails. And in particular, I want them to be clear with the source that they are going to share it with a senior editor and perhaps with their lawyer. Now that's if it's possible. Unfortunately, in my experience, lots of reporters just promise confidentiality without ever defining what exactly that means, and that leaves you in a little bit of a dicey situation. So I would probably tell you, Ethan, if you'd already promised confidentiality, but you wanted the lawyer to vet it, that you go back to the source if you can without spoiling the relationship and say, listen, I need to involve my lawyers in this, otherwise I may not be able to complete the project. So that's the starting point. But frankly, I don't always ask for the identity of the source. In fact, I often don't want to know the identity of the source, because courts have a little more authority over lawyers than they do over reporters because of our bar membership. And I'm always afraid that some aggressive judge or prosecutor is going to take a position that I have an obligation to the court that I'm a member of to reveal this important information if they make the necessary showing. So the answer is I'll often talk to reporters about the source, get general information that might even lead me to a place where I can guess who the source is, but without actually knowing, so I have plausible deniability. As far as the fact-checking part goes, I mean, you're not going to send the fact checker back to your confidential source to ask them questions in all likelihood. But what you are going to want your fact checker to do is to find out if there's contrary information or confirmatory information that surrounds the circumstances, right? whatever circumstantial evidence you can find that supports the confidential source's story, that's all really helpful in terms of feeling confident that you can go out there based on what the confidential source has told you. Does that help?
Yes, thanks.
Okay.
That's very helpful.
All right, I think we're just about out of time. Thank you for joining us. Thanks for your questions. Thank you, Sarah. It's always a pleasure.
Likewise. Thank you, Dale.
Enjoy the rest of the festival. I'm sure that I will, our paths will cross again. I look forward to it.
Yeah, same. And I just wanted to mention,
Thank you, guys.
Thank you. I just want to mention, we do have a new pre-publication review guide that I just dropped a link to in chat. And that
Super
has,
helpful.
yeah, it's got, you know, a bunch of the points that we talked about today. So
It's really
reminders.
quite helpful and really well written. Bye.
And Dale was a great help on that too. He reviewed it and had some great input. So please use that. And we have a hotline. So if you have questions, feel free to reach out.